for joining us today for a webinar in collaboration with the EPAWI project, so European Partnership for Auxiliary Wine Industry Innovation, and also the Latin America IP SME Helpdesk. So these are two initiatives from the European Commission that are meant to help and promote business activity in third countries for European SMEs. So from two different ways, and we're very happy to be hosting this webinar today with the Latin America IP Helpdesk. So first, we will have a brief explanation of the EPAWI project and WICA, Wine Innovation Collaboration Alliance project by myself, Gracie Boland, and I am the project manager of EPAWI, which is through the COSME program, Clusters Go International, and the International Development Manager for Innoven, which is the French Vine and Wine Innovation Cluster based in Bordeaux and Cognac. I'm here today with my colleague Céline Caffo, who is a co-leader of international actions for the EPAWI project and also a project manager for Vinidea, an Italian innovation and research transfer company working on communication in the wine industry. And also we're very happy here today to have Giovanna Girardi, who is a lawyer specializing in business law and intellectual property and an expert for the Latin America IP Helpdesk. So the goal today is to talk about internationalization and IP protection and management in Chile, which is a country of interest for the EPAWI project and obviously for the Latin America IP Helpdesk. So a little bit about the partners of the EPAWI project, which is made up of wine innovation clusters. And so I think if you're in the EU database and cluster interest, you understand that a cluster is a mix of end users, researchers, public institutions, and suppliers of goods and services. And so I think the visitors here today, you represent all parts of the wine value chain. And so we're happy to have you with us here today. The EPAWI partners represent France, Spain, Italy, and Portugal. We also have a willingness to include all European SMEs, and then of course, working with third countries such as Chile. The goal of the project EPAWI, again, European Partnership for Auxiliary Wine Industry Innovation, is to detect and understand the main challenges presented by wine growers and producers, to face these challenges presented by the producers through auxiliary companies' involvement and cross-sectoral information, to promote and facilitate the international development of auxiliary companies, and finally, to establish WICA, the Wine Innovation Collaboration Alliance, as an official structure providing service to the wine industry. And so these goals are also linked to intellectual property because it's a very important part of international business, is understanding how to protect and work in third countries. So the benefits of EPAWI and the benefits of this Wine Innovation Collaboration Alliance for wine growers, for supplier companies, for business support organizations, clusters, business units, and research centers are different, but the main link is international partnerships and working together to support wine innovation on an international level. So a quick overview of the EPAWI timeline and activities. As I mentioned, we started by understanding the challenges of wine growers through interviews and surveys where we identified these challenges. And here is an example of some of the results that we have. So what are the main challenges regarding grape growing? And you see here that we can also separate by country. So for example, in the US, the extreme climate change might be a bit more pressing than cost management. And in France, yield seems to be more important than diseases. So we're able to really see country by country these differences in challenges. And also on a more general level, we're able to see the challenges on an international scale, where we see that reducing additives and obtaining a healthier wine have been some of the main challenges. The next step was inviting the European supplier companies to have solutions for these challenges. And we did that through an innovation contest where we invited European SMEs to give the happy endings to the challenges presented by the wine producers. These stories can be found in an innovation catalog where over 85 solutions are presented by 45 supplier companies in real-life situations. So it's very helpful for the wine producers to see these innovations in a real-life setting, thanks to this innovation catalog and innovation contest. And now, a big reason why we're here today is the international development of European SMEs and also business support organizations on an international level. In November 2023, we had an international event in Chile where over 12 European companies presented their solutions to over 100 Chilean wine industry actors. They presented their solutions, had wine tastings, and also individual meetings to discuss the innovations that are happening in Europe and how they can be adapted to the Chilean market. And so when we work internationally, I think also Giovanna will remind us of this, that adapting is very important. And that was really the goal of the event and the mission. So understanding the ecosystem of Chile and how to work there. And so the main focus of the webinar will be about Chile. And just to conclude about the international development of WICA, we are also working on innovation showcasing online and in person, continuing the survey to continue to understand the challenges of wine producers, and also, as I mentioned, encouraging business agreements and also business support organization collaborations for the future to create WICA, Wine Innovation Collaboration Alliance, as an established collaboration. And so right before we give Giovanna the microphone, we wanted to highlight what we did in Chile and the services that WICA can provide to SMEs. And so we called this a South American wine industry market immersion, because the goal was to learn to be immersed in the ecosystem while, of course, promoting the innovations provided by the companies. So we spent over a week in South America, 1 week in Chile and a few days in Argentina, where we met with groups such as Wines of Chile, the Research and Innovation Consortium, the University of Talca Technology Center, 2 days of an event called InnoForum that my colleague Celine will mention, and then technical visits, meeting producers and understanding their main challenges. And so this is a service that we will continue to offer as the EPAWI project in the United States this year, 2024, and that we hope to continue with the Wine Innovation Collaboration Alliance as an established association. So thank you, Celine. If you could give us a few words about the InnoForum event in Chile.
Yeah, sure, Gracie. Hello, everybody. My name is Celine Cafo, and I work for the company Vinidea. And we are the technical support for this project, EPAWI WICA. And we did organize this event that Gracie was talking about. on the 8th and 9th of November in Chile. And this event is, the concept of the event is Enoforum. It's a concept that has been existing since 20 years, and it was organized mainly in Europe and a little in the United States. And it was the first time we organized it in Chile. And for this, we have to thank the EPAWI project and WICA and the European community, of course. And here on this slide, you can see the 3 pillars of the Uniforum, because Uniforum is not an exhibition, it's not a scientific congress, but let's say it's kind of a mix, and it's bring together the 3 pillars that we think are very important for innovation. And the first pillar is the public research that obviously get the idea of the technology at the beginning. It needs to be worldwide. So we always have people talking from all the continents. And in this case, for Enoforum, it has to be also focused on the practical result that can be obtained and that can be used afterwards by companies to develop the innovation and apply it on a large scale. So the companies that are coming and showcasing their innovation, and then they go on a global scale. That's important that it goes also around the world. And the last pillar is, of course, the people that are working in the business and that might use these technologies, that are the wine growers and the winemakers, that will use the technology or provide their feedback, give their opinion, and also raise some new needs. So these are the 3 pillars that goes in the Uniforum concept. Gracie, could you go on the next slide? Okay, and for this first edition that we did in Chile, as Gracie was underlining it, it was very important for us to understand the ecosystem of the country Chile and the business, the wine production business in Chile. And that is why we have been working very, very closely with the Chilean actors. And on this slide, you can see that we were hosted by the Center of Investigation of Innovation from the biggest company in Chile, Viña Conchetor. And they gave us the possibility to use their auditorium that you can see on the picture, and also the experimental winery, which was very, very nice because we could have this fair where we had some companies presenting some wine of the customer they are working with in Europe. And they could meet the Chilean technician and they could exchange on how the wine was made and to understand better also the need of the Chilean. And this was done in this experimental winery that you can see in the center. Also, we did some networking moments where the people could relax together through lunch and dinner. And this was also very much appreciated. And the reason of the success, because this event was completely full. We didn't have any seats. We couldn't feed the people inside. The reason of this success was that we work with the local association, so the Association of Enologists and Agronomists of Chile, and the Association Wines of Chile, Vinos de Chile, and their research and development consortium. And the program of this Uniforum on the road was custom made for them. So we send them the survey that we've been developing together with WICA and ask them to reply, ask them to ask all the technicians working in Chile to reply. We had many answers and they gave us exactly the theme on which they were, let's say, tackling challenge every day, and they had big issues. And based on this, we asked some universities and research centers from all over the world to come and broadcast their solutions. So it was, I think, a success for this. What shall I say more? That we are running a survey for the participants and for the companies, and we have been having good feedback from both type of participants of the event, and I think it's really because we could listen to the actor of the sector and reply to their needs. So we are really happy about this. And Gracie, would you like to add something more?
Well, thank you very much, Celine. That was a very good summary of the success of the trip to Chile. And we have been following up with some of the SMEs and companies that participated, who have had continued conversations with the stakeholders that they met in Chile. So for them, and also for companies that are already present but are looking to work in Chile, we wanted to provide the Latin America IP Helpdesk service to better understand how to protect and manage this type of content. So thank you, Celine. Thank you to everyone for also allowing us to speak about the EPAWI project before the training starts. So to conclude, what EPAWI and what WICA needs are companies like yourselves interested in innovation, transfer, and internationalization. So whether you are an auxiliary company, a technology provider, a service provider, a wine producer, a cluster, another type of business support organization, or a research center, the goal is to have a willingness to collaborate internationally. And what we can propose, like we're doing today, is expertise of wine market or cross-sectoral competences in different regions, knowledge and contacts, assistance in developing collaborative projects with the different actors, and international development for innovators, such as Celine explained during InnoForum on the road in Chile. So thank you very much for your attention. If you're interested in learning more about the EPAWI and WICA project, here is our contact information. You can follow us on social media, send us an email, and we would be happy also to know about any specific questions you might have if you would like to be involved. And also, if you have any questions, please don't hesitate to write on the chat. And without further ado, it is time to introduce Mrs. Giovanna Girardi, as mentioned at the beginning of the webinar, a lawyer specializing in business law and intellectual property, and an expert for the Latin American IP Helpdesk. So thank you so much, Giovanna. As explained, we have been working in Chile. A lot of our companies that are involved in EPAWI have questions about this market, and so we're happy to be able to provide this training on IP protection and management. And so I will let you now share your screen, Giovanna.
Thank you, Grace. Thank you, Celine. Thank you, everyone that has joined us today. I know I've always thought that wine people must have been the happiest people in the whole world. And I think I'm not mistaken, because if you can present a solution to a challenge, you already know you are in a minority in this world. So it seems like you're doing an amazing job because you are in an amazing industry.
That's true. We are lucky, and we have lots of innovations, innovative companies that work hard to provide those solutions.
So every time I am asked to talk about challenges, is always hard for me, because it may give the feeling or the sensation that is too negative, no? So I'm going to try not to be too negative too, because I know you guys are always looking for the solutions. So before I deep dive into what we're going to talk about today, I'm going to introduce a little bit about our services, who we are, what we do. We are an initiative of the European Union to raise awareness about the use of intellectual property rights as a business tool for European SMEs. Our services are free, confidential, business-oriented, and delivered in 5 different languages. We also have sister projects in other regions. We have a sister project in India, in China, in Southeast Asia, and Africa. So our services, whatever you see here in our service regarding Latin America, you can also find for those regions. We have a helpline, which is a first line of assistance in English, Spanish, German, French, and Portuguese. Our helpline aims to reply to all your queries within 3 business days without any charge and with the utmost confidentiality. We also provide training like the one today, free of charge, business-oriented and jargon-free as well. In the next month, we have quite a number of trainings. Some of them are in specific countries in Latin America. Some of them are more general. But all of them are incredibly interesting. We also have online resources, guides, case studies, and content on country by country. Here you see 2 of our guides. One is a country fact sheet where you can have more details on intellectual property rights in Chile, and also a factograph, just to understand the main big numbers there. Now, let's deep dive into the challenges you may be facing in regard to intellectual property rights. These challenges, they are not only geolocalized in Chile, but they are widespread. Because when we talk about innovation and intellectual property and rights, the challenges start popping. So this is not in a specificity for Chile, but you will see there too. Among them is the lack of knowledge, what exactly IPRs are, what exactly they grant you, what can you do with them, why do you have to consider the territorial aspect of intellectual property rights, cultural and language barriers you may face in Chile, the need for local representation, the maintenance of rights, the defense of your rights, and of course, infringement of third-party rights. So these are the main challenges we'll see this morning. We start with intellectual property rights territoriality. Trademarks, designs, patents, utility models, they are all territorial. So we need to seek registration and protection locally, there where we have a commercial interest. It's not enough to have this registration and protection in our home countries. It's necessary to pursue that. And here I am going to have to pause and make a little side comment here. I talk about registration and protection because registration is one step on your protection strategy. Protection is not registration. Registration is part of a protection strategy. So there's a need to adapt to the protection or the registration strategy accordingly in the country, because locally you may have a series of rights. Not all of them will be used in your internationalization, or some of them are more apt to achieve your goal when reaching a new market. So all needs a little bit of pondering and adapting. At this point, I think we need to be incredibly aware of lack of registration may, depending on the right we are discussing, may mean loss of rights. Lack of registration may mean loss of rights. That means you are unable to use and exploit. We have also to be aware of local partners and collaborators. In Chile, we have a system, an IP system that is first five, first serves based. That means if the right has been registered, is not available for further registration. So that means the first to register a right has priority. Thus, we have to keep our eyes open with our local partners. We'll see in our case study I brought today, it happens quite often that our potential partners and collaborators see a weakness in our intellectual property strategy and they take advantage. And then later on, we have a little bit of a headache trying to recover our rights. So let's focus on finding the solution. So here the challenge is registering your rights as soon as possible in Chile, and possible challenge you face in regards to this, that local partners are a little bit faster than you. Then we'll find the solutions at the end. And we also have to consider legal deadlines. When we're talking about trademarks, legal deadlines are not that stringent. But when we're talking about designs and we're talking about patents, legal deadlines are of the utmost importance. We cannot miss them. The territorial effects is, for example, when in regards patents, utility models, and designs, novelty is a global requirement for registration and protection. So your innovation, the technical solution, or the aesthetic feature you have created has to be novel, not only in Chile or in your home country, but worldwide. And the territorial effects also bring a priority system and grace periods. It's likely that when we are registering our patent rights and our utility model rights and our design rights, it's likely that we first do it in our home country. And then we internationalize that either through the international system or directly to the target country. And that's where you see I'm talking about the deadlines, the legal deadlines. You have 12 months. You have 12 months from the first filing at the home country to either request the international system protection or request the protection in the target country. So that's the priority we'll have in terms of patents, designs, and trademarks. Now, I think it's important that we actually understand what exactly a patent is, what exactly a design is, what exactly a trademark is. And I'm going to go for that now. A patent is an exclusive right to use and exploit an invention. An exclusive right to use and exploit a solution to a technical problem that has an industrial applicability. A right to use and exploit is a right to sell either the product or the process you have invented, a right to license that product or process, a right to distribute that product or the process, where that right is in place. The right is in place when it's registered. Now, the requirements for a patent is, like I started at the beginning, novelty, which is a worldwide requirement. It has to have an inventive step. An inventive step is the step an expert in the field would have taken to reach the solution that is non-obvious. So an expert will reach that solution in a non-obvious way. This is an inventive step. And industrial applicability. The duration is similar to what we are experiencing in the duration of this right is similar to what we're experiencing in Europe, 20 years from the filling day. There's no renewable. There's no possible of extending that term. And we also have to pay attention to matters of disclosure and priority. Disclosure here too early. When we have a disclosure too early, that means we publish our research, or we present it in a trade fair or in whatever, make it public before filing for our patent rights request. That disclosure may hinder the granting of the right. So it's important to, if we are disclosing before requesting the right to the relevant authority, we have to make sure that we comply with their grace period, their disclosure grace period, which is generally 6 to 12 months. My recommendation is do not disclose anything before a formal request has been filed, at least locally, at least at our home country. Let's talk a little bit of designs. Mind my wine stoppers there. They are very cute. Designs are exclusive rights to the use and exploitation of the aesthetic feature of an object. In Chile, is the external appearance of a product. It's the exclusive right to use and exploit the external experience of a product. A wine stopper, a box, whatever you be dealing there. The requirements here are also novelty and non-excluded matter, which is no internal design. It has to be an external feature of the product. The duration of a design, the term of duration or validity of a design is 10 years from the application date. And likewise, the right to use and exploit is the rights for you to trade that design directly, use that in your product, or license it, grant the right to use and exploit to a third party. And last but not least, the trademarks are the exclusive rights to use and exploit a sign that you're using in trade you're using to trade a certain product or service that is capable of distinguishing the offer of different business. In Chile, it has to be graphically represented, it has to be distinctive, and it has to be available. So one availability is one of the requirements we actually have spoken about at the beginning of the session. Availability means we have to pay attention to territoriality principles we have to seek registration in Chile. Also, it has to be available. Nobody else has to be nobody else has to have registered before us. If there is a prior register right that is identical or similar, we will have problem reaching the registration. So territoriality, timing, and availability is of the essence here. And graphically represented means that we won't be able to register non-traditional trademarks such as smells, scents. The Chilean authority is not yet registering these non-traditional trademarks. They are not graphically represented. And here in my example, for us to understand how important it is to connect territory, Chile. This is a trademark register in Chile for wine articles, wine devices, wine dispensing devices. So we are connecting a symbol. In this case, is a name. In this case, is a name. We're connecting that name with a particular product in a specific territory. Now, this particular brand also has, apart from the name, Corevan, it also has a symbol there. I don't know if you can see this little, I don't know, it's like a head of something or wings. That is also a symbol they are using in trade to distinguish their products from the others. So that is also a trademark, and that would have to be registered in connection with the products they are trading in the territory they are trading. I've been throughout our session trying to convey the mean. What does exclusive rights, what does it mean? And again, is the use and exploitation, the direct sale or the license or other type of contracts of that right, of that specific right. Be it a trademark, be a design, be a patent, etc. If you have them, if it's correctly registered, properly registered, that enables you to exploit it. The second level of use and exploitation is the right to enforce these rights against unauthorized use. So use is, it means use it directly through your company, license, sell it, etc., and enforce it. Or, in other words, defend your interests or the interests of your company or the interests of your rights. And here enforcement can be done including through the courts or including through court actions, but not necessarily. Enforcement starts with monitoring, which we'll see in a minute, which is one of the challenges we have in terms of intellectual property. But monitoring the market to detect early and often an infringement, and pre-litigation, pre-court actions sometimes are enough to deter infringement. Now, how can intellectual property rights be registered then? It's a formal request to the national office, the National Intellectual Property Office of Chile in this case, or through the World Intellectual Property Organization. However, you can choose the national office for trademarks and patents. However, designs, there is not a choice. Designs are only registered through their national office because Chile is not a member of the Hague Agreement yet. So when we're talking about patent, utility models, and trademarks, we are able to choose either World Intellectual Property Organization for the registration of rights or the national office. Now, it's also possible to register rights with customs. It's not necessarily, but in Chile, it's not necessary, but it's possible. And the benefits of having a rights register with customs is that the authorities have to inspect whatever is coming in and coming out of the country. And if they ever find anything, they have a way to contact you for you to take action if you find it is relevant. The international system, Chile is only part of the Patent Cooperation Treaty for patents and the Madrid system for trademarks. So for those two, like I mentioned before, you'll be able to choose either the national office or the World Intellectual Property Organization, always with a formal request. That formal request will be examined. There will be a publication. After the publication, there's an opposition period open. If everything goes smoothly, your right will be registered. If we're talking about the trademarks, within 6 to 8 months, and we're talking about a patent, perhaps 2 to 3 years. Now, our next challenge in Chile will be possibly cultural and linguistic barriers. Now, what can we think about cultural and linguistic barriers in terms of intellectual property? How different cultural values could affect the perception of the product or the service? Is there any difference in value that could affect the perception of the product? Or even the understanding of the name we chose to trade with there, or the design we might have chosen to trade with there. Any specific association with certain colors, symbols, names that could influence the perception of the brand and the product in that market? What was the intended semantic meaning we wanted? And be careful, obviously, with bad translations. And here we have one of them. Though neither of my examples, these two examples, are not in the wine sector, I think they bring a very clear understanding on what bad translations are. So this Jeep in some countries are called Montero because countries in Latin America, they were called Montero because their original name had a very bad connotation in the local language, which is Spanish. Pajero, I'm not sure if you're familiar with the word pajero in Spanish, is slightly offensive to the male that likes to treat himself too well, perhaps. So they had to obviously change the name of the car, the brand name, to fit the local market. And another example we had that perhaps was not related to bad connotation, but with a strategy, a business strategy there. The ice cream company decided to maintain the local brands They have purchases a small business around the globe, and they have maintained the traditional or the original name of the business they have acquired. However, they decide that to build a strong image, their logo or the design of the figurative element that goes together with the names in the different country is the same, creating a global identity. So one solution is not always the same for everybody. The solutions you may find within the challenges you face, be it a bad translation or be it not great connotation in the local language, or be it because we are acquiring business, the solutions we will face in terms of intellectual property are different and have to be weighed down to see if what best suit our needs or how it best suit our interests to reach the goal we have in that region. Now, if we decided to, or if we choose to register our rights through the national office, local representation is a need, is a must. If we choose the national office, we're going to have to find a local expert in intellectual property to help us. We're going to need a dress for serving in Chile. If we use the international registration system, if we choose to use WIPO, it's a possibility. We can have one, but we don't need one unless we are facing trouble in the process, the registration process. If our international registration process goes smoothly, is a possibility. We can decide. So here another weighting scale for us to see what works best in our strategy. Our next challenge is maintaining our intellectual property rights. Like registration, like I said at the beginning, is not protection. Registration is one step in your protection strategy, and maintaining your rights is another step in that protection strategy. Now, to maintain your rights, there are a few things we need to take into account. One of them, which is really important in Chile, is to indicate that trademark, that trademark or that design or that patent is registered. Whatever we're using in our packaging, in our web, in our content, there has to be indication that our right is registered. Otherwise, we won't be able to initiate criminal actions against infringement. So that is highly relevant to the protection of our rights and our interests in Chile. The second thing we have to keep in mind is fee payments. We might need to renew, and we might need to pay annuity in the case of patents. Also use is how maintaining the contracts we have, the NDAs, the license, the distribution, the agents agreement, everything we have, how we are maintaining, how we are assuring that however our product or service is reaching, the quality is assured, our customer is happy, how everything is building up into maintaining a goodwill and maintaining our intellectual property right. The next step or the next challenge, or the next step in the protection is the defense of our rights. So we've been maintaining our rights. Now we've been also monitoring the marketing. We monitor what's happening. We detect infringement. We acquire proof of infringement. And then we have enough means to enforce our rights. Now, infringement detection and proof of infringement that include customs. If something happened in customs, if something happened in a specific marketplace, if something happened in a digital marketplace, we are always continuously monitoring what's happening there and taking action repeatedly, week after week, monthly after month, continuously. This is a work that has to be done on a regular basis. Control expectations and cost management. Infringement can escalate while registering our rights in Chile, maintaining our rights in Chile, and monitoring our rights in Chile is fairly cost economically. Defending a rights can rapidly escalate the costs. But it's something we need to be prepared, because it's a challenge. The wine industry is not safe from infringement. Actually, we have seen a very big growth in infringement in the wine industry, be it products and services that products that serve the wine industry, or wine. Actually, we're seeing an increase of infringement or violation of wine producing. Preventive measures here are important, and also be prepared. Like I said at the beginning, no, you're not always going to have to go through court. Court is the last resource you have to enforce your rights, but you also have previous measures. And one of these previous preventive measures is, once an infringement is detected and proof has been acquired that that infringement has happened, we issue a cease and desist letter. A cease and desist letter is an information that we have proof that that happened and that right is ours and that needs to stop. It's simple and very often very effective. We also have injunctions, preliminary injunctions to defend our rights. And here, like many other countries, if we have to record to courts, we can actually choose between civil and criminal remedies. And here there's a lot of things that you're going to have to deliberate with your expert, with your lawyer. What is better to choose civil or criminal remedies? There are different type of remedies. Civil are generally looking after compensation, and criminal goes a step further. We are not looking only compensation, but actually a punishment for that infringement. Now, we cannot forget, and this is the very often overlooked challenge many companies face, because companies are made of people and the information runs loose through people, no? So this is the infringement of third-party rights. That means not someone else infringing your rights, but you infringing somebody else's rights. unaware of a certain word is a trademark, or unaware a certain color scheme or photograph or whatever has proprietary rights, etc. So here, the way to solve this challenge is raise the amount of information everyone in the company has on how to avoid claims, how to avoid action, how to avoid cause, how how to avoid infringement. Apologies.
If you need to have some water, Giovanna, please, please go
Thank
ahead.
Now, one way to also overcome this challenge is always take a step further. Always take an active seat and do your searches, your trademark searching, your freedom to operate, etc. I have a photo. Is this photo mine? Do I have the rights for it? Can I? Is always the way to overcome challenges in intellectual property is always taking the active seat, proactive seat. I'm taking the measures on my own hands, if you want to say it, and be proactive. Do your work beforehand. And knowledge. Look for knowledge. And knowledge it doesn't it doesn't occupy space, so we can always have a little bit more. And is the way to overcome all the challenges in intellectual property. Also, here another way to overcome infringements is, in case we have detected we don't have a right to something we want to use, be it a design, be it image, be it trademark. Seek for the authorization of the owner. Seek an authorization. I know you have this. This is yours. I need authorization to use in this and this way. It's not always easy, but it's the best way to avoid claims and costs. Now, I'm going to finish it up. No, I'm not going to finish it up with this, but I'm going to enter into this case study, which clear touches a lot of the things I have said today. In this case study is a bad faith registration. We have a Spanish company, a medium-sized company. This company had relationship with a local distributor. After many years, they broke off the relationship. And they came to realize that the distributor had registered their new logo without informing them. Now, their solutions to this challenge, the solutions the Spanish company had, was objecting the registration through an opposition, or later filing a cancellation of the trademark on the grounds of bad faith. They decided to send a cease and desist letter. They inform their distributor that they were going to be opposing unless they withdrew or transferred their trademark application. And that cease and desist was enough for the distributor to withdraw the application, the trademark application, from the the registry. Not often that is enough, and when that is not enough, you have the legal action. of course, is not is a headache, and it's not nice to depend on a process and waiting for a process where you actually have to be trading a process. A legal process may take 18 months, 24 months, and throughout that process you have the insecurity of not knowing what's going to happen, because there is a third party that is going to have to decide. In this case, the proof of bad faith was evident and possible, that though you have to wait for the process, it's 90% certain that the result will be positive at the end, but that is not always the case. And when that is not always the case, is a big headache for the business. Thus, I insist, it's better to prevent, to act early, than have to deal with these headaches. Now, of course, it's not all challenges in Chile. And I don't want you to go onto your days thinking it's all challenges. It's not. The Chilean legislation ensures strong standards of protection of intellectual property rights. They have a high effective of public innovation initiative. They have a high level of legal certainty. The courts are used to intellectual property case, and courts are or have been dealing with in a fairly way. And on top of that, Chile has a strong culture of innovation. So you're target a good country. There's only minor details that you have to look, at least in what intellectual properties relate. You just have to pay attention, do your homework there. But it's an excellent, Chile is an excellent country to do business. And with that, I leave here our contact details. You may request a meeting with our experts through our page, either through the social media outlets or our SEMI web page, the IP SME Helpdesk. And with that, the floor is yours to ask me anything you want.
Thank you very much, Giovanna, for this very clear and interesting presentation on IP protection and management in Chile. So we see that it's important, obviously, for the registration in your home country, but that right when we start thinking about export markets, it's also a subject that we should have in mind when exploring a new country. So I invite the participants to write any questions in the Q&A section if you have them. So I don't see any questions right now. The cost. Yes. So what about so the IP help desk is free for European SMEs, if I understood correctly. And what about the cost of registrations in Chile, for example? How does that work when you're managing export markets?
Okay, so the cost of the services are free. Our training, our resources, everything we provide, our first line of assistance is free. Your meeting with the expert is free. We encourage you to use our services, because the more our services are used, the more the commission is happy with us, and the more we're able to further provide the services. The costs, the registration costs, is two variables. here, okay? Be a trademark, be a patent, be a design. There's two variables, at least two, no? One of them is the official cost, how much the agency we're going to use is going to charge, the official governmental agency, the National Intellectual Property Office of Chile, or the World Intellectual Property Organization. No, so there is an official cost and there is a service cost. If we're using a service provider, there will be the service provider cost, and there it varies quite a lot. I would say service providing cost will be, if we lend the costs into what a trademark may be, let's think about 300 and 500 euros as a service cost. And then as official cost, as an official cost, it could be 120 to, depending on the system we are using, 120 with the WIPO will be a little bit more expensive because there is a base fee. It is interesting using WIPO, the World Intellectual Property Organization, when we have at least 3 or 4 countries of interest, to bringing down that cost of the base fee, the base official fee WIPO has. No, so there you might be looking at maybe 800 euros. Okay, but it's always nice if we have a specific question, a specific countries, a specific need, we can get that cost nailed down for you. The official cost, the service cost, we don't provide the registration cost because we don't provide that service. But at least what the governmental agencies will charge, we have that information easily available. Now,
Thank you. And so do you advise using a service provider? Just to
yes.
complete this question before the next one. Yes, okay.
Yes, but here, attention, because if we decided to use the national office directly, that is not a recommendation because that is a need. You must have a local representation.
Okay.
If you using WIPO, you may choose to use a service provider, in which case I always recommend doing it, but it's a choice. It's always a choice. In the other case, is a need.
I see. Thank you.
You're welcome.
We have another question. Could you perhaps clarify the difference between contributor and enabler of IP when deciding on each party's contribution to the particular IP?
Oh, this is a very tricky question, huh?
This vocabulary that's a bit nuanced and...
Is somebody trying to catch me here? So I imagine here there's a little bit of background here into this question. Do you want the person making this question would like to make any clarification on the little bit of this background, so I understand what exactly she meant? From what I understand the question here, okay, this is when these terms are used when we are working together in research and development. I don't know if that's correct. If that is incorrect, if my understanding is incorrect, please. Okay, that's correct. Fantastic. So here is a lot of problems or potential problems. They are not problems really, no? When we are collaborating, who is doing the work? The two questions we have to ask who is doing the work, and despite of who is doing the work, the answer to the second question is, how will the parts benefit from the result? Yeah. So the two important questions in risk, or among the many important questions, these two are highly important. No, we are collaborating to reach a result, and then we don't know that when we get the result, we don't know yet who has collaborated the most to that result. But that doesn't matter, because we can either preempt that in a contract or not. But what is important to preempt is how the result will be, the results or the exploitation of that result will be distributed. Generally, we talk about the enabler. Generally, the enabler is the one that is more business savvy, is the one that perhaps is not going to contribute so much into the result of the research, but will contribute into that reaching the market and being a success in the market. So the division of the exploitation of the result, it doesn't necessarily has to be 50-50. It can be agreed according to how much with calculator the enabler can make this a success, or how the enabler, how could we live without the enabler? I don't know if that answered the question of our guest.
So if I understood correctly, it's really defining as early as possible the different roles with the partnership.
Yes, you define the different roles of the partnership, but I'll go a step further. It's not only that. It's because here, what the challenge is there is that we are doing something together, but we are unaware, or we are not sure what is the best way to divide the proceeds when they arrive.
Right.
But at the moment, we don't really know if there's going to be any proceeds. So it's just trying to, I like to think of contracts or collaborating contracts as a mechanism for us to be able to work together, not a mechanism for us to defend from each other, because we need our strengths, our different strengths. So within our different strengths, how can we put in the paper in a way that enables our relationship, in a way that everybody's happy?
Yes, it's important for R&D and also for the client distributor relationship. I know that a lot of our SMEs working in Chile are looking to work with distributors. So it's important to have that in mind as well.
Yes.
I had a question about disclosure. Because as the EPAWI project, we are promoting a lot SMEs, organizing online pitches, conversations. The companies presented their technologies with quite some technical detail at the conference. And so how is the disclosure measured? I know that's maybe a hard question as well. It's case by case, but do you have any more insights on disclosure and how to also protect with disclosure?
So I'm going to put it into examples, okay? I'm going to try to make it very digestible there. I had a client, for example, that we applied for a design right in Europe, in Brazil, Argentina, the United States, and the UK. And the US as well, okay? In the EU, the UK, Brazil, the design was granted, no problem. In the EU, might be the case because we don't have an examination. The examination of the design only happens after registration in case someone challenges it. There's no an official examination of the novelty requirement, no? However, in the US, our design was denied because the examiner in the US was able to find a photograph in the client's Facebook page 3 months before the first formal request. A private Facebook photo that was public in Facebook, that the examiner, I don't know, the examiner might have been having fun in Facebook, looking his own things, and he found it. He may be a Facebook fan, we don't know. I don't know many examiners that look into Facebook to find disclosure, but it may happen. Okay. And unfortunately for my client, it happened. He published that photo 3 months before he the legal deadline lapsed. So he was unable to save the right in the US. And the worst of everything is that because that is a public record now, that there was a disclosure before the time. Now, if anyone challenges the right in the EU, for example, where there was no examination, it's likely that that right will be cancelled because of the disclosure. So the disclosure is, it could be anywhere. A physical mean, if it's just a word of mouth, nobody can, like, for someone to remember and to put it in a paper, and that's more complicated. But any a disclosure made through a physical mean, be it online or offline, that's where you have to be careful.
Thank you. That it's clear, and the message is to be careful and to plan ahead. From what I understood. So I don't see any more questions, and I see that we're almost at 1:30, so the time to say goodbye. Thank you very much, Giovanna, for this very clear and interesting presentation that is helpful for our project, and I hope for also the participants in their individual needs and interest in IP management. Thank you also the Latin America IP Helpdesk and the European Commission for the possibility to be able to provide this training to the interested parties. So I think, as you said, the IP Latin American Helpdesk is available for any specific questions that the participants may have. We will send a follow-up email with the contact information so that everyone has that, and as well for the EPAWI project for the participants that are interested in internationalization and the wine industry on a general level.
Thank you. Thank you, everyone, for joining us today.
Thank you, everyone. Have a great day.
Thank you, everyone.
Bye-bye.
Bye.